I am a widow, but have remarried. So I've been married for 7 years now. I have 2 grown daughters. I have a will. I have the 3 legal documents: the will, the healthcare surrogate, and the power of attorney. But I'm wondering if I need a trust. I also, before I go there, I also was advised before I remarried to have I'll call it a residential prenup that my new husband was totally agreeable to.
Okay.
But I don't know if I need a trust or not.
So, Kathy, first of all, let's start with this, that by the very fact of being married here in the state of Florida, your new husband automatically has rights to your estate. 1 has to do with the home that you live in. 2 has to do with everything else. The home you guys are living in, is it in just your name?
Yes.
And he signed some kind of limited prenuptial agreement saying that he makes no claims on that.
Correct. Before we got married, he did. And it's notarized and in the vault, if you will.
All right. Kathy, here at the Olson Law Group, we are all about helping people to avoid probate. We consider a trust to be a complicated tool for avoiding probate. Generally, our clients, maybe even you too, can use simple tools for avoiding probate. So first of all, Kathy, some kinds of assets don't go through probate, like IRAs, retirement accounts, life insurance, annuity policies. Anywhere where you get to name a beneficiary, you can assume that it's not going through probate as long as you've named your daughters or your husband as a beneficiary. Number 2, cars, boats, vehicles don't go through probate. Then if you have any bank accounts in your name only, checking, savings, CDs, money markets, you can avoid probate on those by making them POD, payable on death to your kids or your new husband. And then there's a ladybird deed to avoid probate on your home. What do you think, Chrissy?
So yes, Tom, thank you for that. And to add, Kathy, here's the situation for you. This is where you may need the trust. Because Tom's right. We're about keeping it simple. However, so right now, you know that your husband does not have the claim to the home because of what he signed. However, because the home is in your name only, and you may want to protect him, if you were to pass away and you want to know that he has a place to live for his lifetime, then your home goes to your daughters, that would be a trust.
Excellent point, Chrissy. So, Kathy, if you said, hey, if I die and my husband survives me, my daughters get my home, he's out, he's got to figure out where he's going to, well, we might not need a trust. Kathy, you said, hey, I want my husband to be able to live in my home for the rest of his life, or for 1 year, 2 years, 3 years, then we would be using a trust to accomplish that goal.
So verbally, right? We have these conversations, so there's nothing hidden here. But verbally, he knows he can't maintain this house.
Okay.
So he would leave. Okay. I mean, he would go to an apartment easily.
So I think the only reason we would need a trust is if he wanted to stay in the house for a period of time, so we can get back to the simple tools, Linda. By the way, Linda, if you own any bank accounts jointly with your new husband and you pass away, those bank accounts would automatically belong to him if you were to pass away, Kathy.
They are not joint, and they're both POD.
Okay. For your kids?
Yes.
Okay. Kathy, I want to make you aware of one more thing. We talked about Florida's elective share law. By the very fact of being married, your husband has certain rights. One right has to do with your home. You've covered that with your homestead prenuptial agreement. It's a limited. Usually they're broad and cover everything. Yours is only covering your home. The other thing has to do with the other elective share has to do with that he's entitled to at least 30% of everything else. So, Kathy, if between your IRA, life insurance, money in the bank, you have $300,000, you might want to try and leave that to both of your daughters, and yet your husband could step in if you passed away and say, I don't care what her will says, I don't care what her POD accounts say, I want what I'm entitled to, and that's 30% of that $300,000.
Okay.
He doesn't have to take it, but he can if he wants to.
I see. On my well, they're now retirement funds. They're not IRA. I mean, they are Roth and invested. I'm since retired, and he's retired, and he will be the beneficiary to my retirement funds with our children, respectively, secondary with a quarter each should something happen to him.
Okay. So
Is that, I mean,
Kathy, I didn't quite get that bit of detail. We've given you a lot of information here today. You start off by saying, do you need a trust, Kathy? All in all, I think it'd be wise for you to sit down with an estate planning attorney and review the documents you have, review the plan that you have in place, and then factor in this Florida elective share law as to what your husband would be legally entitled to if he wants it if you were to pass away, Kathy. I think that's about as far as we can go. Kathy at the Olson Law Group, we'd be pleased to assist you with that. You can call us anytime, including right now, 407-423-5561, or you can always reach us through our website, olsonlawgroup.com.